my Lord, if His Lordship would respectively pay attention to the precise contents of the request. The Crown, my Lord, is requesting detention of the exhibits handing over to the requesting state, which is the SAPS, my Lord. Yes. Now, my Lord, with respect, our submission is we are being placed in an invidious situation, or rather a position, my Lord, because, my Lord, it would be immaterial for us to make or take a position now prior to having received the comprehensive application for extradition, my Lord. Reason being, after receipt of that application, my Lord, that is when we will be able to sit with our clients to take full instructions, my Lord, inclusive of the application for detention of the cell phones. Now, it would defeat the whole logic and or purpose, my Lord, why we would be dealing with this application now, instead of dealing with the application simultaneously with that for extradition. So the submission is quite simple, my Lord. We are of the view that the application for detention is premature because it is specific that is for subsequent handover to the SAPS, my Lord, with respect. Therefore, my Lord, having said that, we are highly opposed to the application for detention. To the best of my recollection, this court had actually issued an interim order for provisional detention the last time we were in court. We would have applied that rule be extended, my Lord, as opposed to granting a final and definitive order for detention, my Lord.
Ngekubuka kwakhe na ubuka kungazuthi ke lenzaba yalesicelo lesendiwa ukuthi kugcineke lamazibiti lawa ngeke ukuthi bafuna ukuthi bese bawamikisa ke kulamaphoyisa ase-South Africa kungathi ke kuyinto levele ngesikhathi lesingasiso ngoba bona batawukhona ukuthi bafune kuphendula kuko konke lokhu nasesekufikile lesicelo lesibuya kulamaphoyisa ase-South Africa bese bayakhona ukuthi baphendule sebaphendulela konke. Nyalo inkantolo beyikhiphile sijubo zokuthi ke letinciko leti aqhubeke igcineke ngemaphoyisa angacela ukuthi kuqhutshekwe kuleso sijubo ngokuthi siqhutshekisele phambili.
Yes, and my Lord, with respect, may the court also take into account that the status quo prevailing currently, there is no prejudice that is being suffered or that will be suffered by the Crown in the event this honorable court does not grant a final and definitive order for detention, my Lord.
Phinde futhi kude lapho umshushisi athinyabezeka khona nangabe le inkantolo ingasikhiphi isinqumo sekugcina ke kule ndzaba le yalo ukuthi kugcinene lamazibili.
Yes, my Lord, fortunately, my learned friend made a submission before this honorable court that they were still within time. Which buttresses further the point that there's no prejudice to be suffered pending receipt of the full and comprehensive application for extradition, my Lord. We will holistically deal with both applications after having had the privilege to then take full instructions after having been served with the application, which is pending service before this honorable court, my Lord.
nasesekwentiwa nasekufike nale maphepha lalenzele ukuthi-ke afike batawuse sebayakhona ukuthi baphendule konke sebakhone ukuthi bakumiselele-ke nabo umsoco.
And for the record, my lord, we intend to even instruct counsel for the actual application, which will also require a further consultation and instruction on how and in what manner to proceed, my lord. So the long and short of it, my lord, is we are opposed to the application for detention. May we kindly be furnished with a comprehensive application for us to take full instructions, and we shall accordingly revert to the Crown and the court, my lord, as to our position.
Sike loqhubeka-ke kwaleli cala basatawufuna ukuthi baqashe-ke labanye-ke labantu abasita nokuthi-ke vele-ke bayaphikisana nalesi sicelo esendiwe-ke ngomshushisi-ke phambi kwenkantolo. Bona batawubuya batokwenta lokhu nokuthi nana naye nalabantu basetamcasha sawufuna naye ukuthi-ke athole ukuthi-ke afunze lawo maphepha akhone ukuthi naye atinike isikhathi bese-ke sebayakhona-ke ukubuya-ke batewuphendula konke sekukanye.
Yes, my lord. I cannot take the matter any further, my lord.
Your Lordship, Your Lordship, on the issue of prejudice, Your Lordship, there is nothing my learned friend has advanced before this honorable court showing that the granting of a final order, Your Lordship. By granting the final order, Your Lordship, the respondent will suffer any prejudice. That is tried law, Your Lordship, that if an application is opposed on the basis of prejudice, they must advance the reasons why they say they will suffer prejudice. Otherwise, it is normal when you apply or when you seize items from a suspect, they are detained. Your Lordship, our problem is that these cell phones do not form part of the request, the extradition request. These are items that it's a matter of on its own. The extradition request will come with the contents, whether there is a prima facie case or not, as per the extradition law, Your Lordship. That details that if there is an application that has been made, the requesting state must indicate in the request that there is a prima facie case upon which the respondent will be required to answer in his home country, Your Lordship. This is not part. These cell phones do not form part of the extradition request, Your Lordship. And I don't know how my learned friend is marrying the two.
Seke umshushisi lokuyingqinamba lenkulu ukuthi kule application noma kule sicelo lesitawu le ndzaba yale tincingo ayikho yona akukhulunywa ngayo ngoba yona le ndzaba lesicelo lesitawu sitabe sichaza ingcikitsi ukuthi yini imbambambamba-ke lokwenta ukuthi vele kuthiwe ababuye bate ukumelana nemacala abo.
Yes.
Necessary implications, you are saying cell phone by the application, by the applicant during the hearing, substantiating the application. Is that what it's
That is actually what we are saying. We are saying this. We are not relying on the cell phones for the purpose of the application of lordship. These cell phones, lordship, if there is anything that is relevant to the case, will be used in South Africa, lordship, during trial. This is not trial yet.
Ukuthi ke lama cellphone ke ngeke asetshenziswe ke kule ndzaba lena. Lama cellphone nangabe kukhona lokutawutholakala kungasetshenziswa laselitekwa ke le eSouth Africa nyalo kusengakacali ukutekwa lecala.
The only duty for this honorable court, your lordship, is to determine, upon perusal of the application, your lordship, whether the contents shows that there is a prima facie case against the respondent, your lordship, upon which they are required to answer in their home country, your lordship.
Sike umsebenzi wale nkantolo kusike ibuke ukuthi ngabe vele naseyibukela amaphepha. Kukhona yini lokufakazi lokuveta ukuthi vele kuyadzinga ukuthi bahanjiswe bayele event labo ukuthi ke bayophendulela le kulokhulunywa.
That is all, your lordship. In short, your lordship, we indicated that we are abandoning the issue of the release of the self-constituted South African police, your lordship, today. That will be pursued in the near future.
Sike bayaphoxisa ke lokho ukuthi letincingo ke bathathe thatha bayotiniketa ke emaphoyisa ase-South Africa lokho sekuyambiwa ngayolunye lusuku.
Yes.
There's nothing.
The lordship has not substantiated that position, lordship. We applied for the final detention order. He is opposing it. He is the one who must tell the court what prejudice he will suffer, because we are acting in terms of the law, your lordship, that this exhibit be detained pending the granting of the request, your lordship, before this honorable court. Otherwise, if the court grants this application today, lordship, there is nothing that the respondent will suffer when we adhere to the law, lordship. That's all.
Yes, I will give you applications, those things. Yes, saying cell phones should come out. So, what do you say?
Yes. Thank you, my lord. My lord, with respect, for the coffee bet Howard, my lord, and the proposition by my learned friend, to say the least, we are of the view that it is quite upset. This is the reason, my lord. My learned friend is basically, I'd say, giving evidence from the bar. What he's doing, he is preempting what ought to be in the application, which application is not before this honorable court. In short, he is telling this court that he is aware of the contents of the application, yet we are still not aware of the contents of those arguments, in that application.
I object to that. That is not the correct position. I even said so.
But my lord, if his lordship, my lord, with respect, if his lordship could take the submission in contents, my learned friend is preempting the contents that will be contained in the application for extradition. He has just made a submission before this honorable court to say the cell phones will not form part of the extradition application. However, my lord, the question then becomes, how does the applicant know that, because we are not the requesting state? The requesting state is the Republic of South Africa. They've been making submissions to say they're waiting for an application from the Republic of South Africa. How is it then possible now, my lord, before court to know the contents contained therein and whether or not the cell phones will be involved or not, my lord? That is the first question. The second leg, my lord, with respect is, yes, the court, please.
Umshushisi nakethathe kilonda ke uthi teke le kule application letako ngeke kube khona ke letindzaba talama cellphone ekhona. Uyabuta ke ummeli ukuthi kungasi umshushisi so ufuna ubufakazi yena lokuthi ngathi so uyati ukuthi kule application letako kuyini lokubhaliwe khona ngoba nawo so uyasho ukuthi ama cellphone angeke abe khona kanti phela leyo application itabe iqhamuka kulabo base South Africa njengebantu bacela bomhlola ukuthi babuyisele eveni labo. So kwathi ngani ke yena no
Yeah. Can I proceed, my lord? Thank you, my lord. And then, my lord, the second leg is, my lord, this honorable court, specifically this court, my lord, is known to be the bearer of justice and not injustices. How, my lord? We need to always maintain the principle of ode alteram patem principle, my lord. We do need to take full instructions. That's the principle of fair hearing, my lord. We cannot run the risk. I am standing here as a representative. I work on instructions. I cannot take decisions in the absence of full and further instructions, my lord, being furnished to myself or our offices, my lord, as the legal representative. So that principle of ode alteram patem should not be jeopardized, my lord, because, my lord, already the court has given us a quasi-remedy to say we have a provisional detention order, my lord, which means the status quo prevailing will still be maintained with respect, my lord. There will be no prejudice, because that's the main question, my lord. What prejudice is the applicant going to suffer in the existence of the provisional detention order? The question is none, my lord. Then we come to the second leg of my learned friend's submission to say, no, we have then elected to abandon the detention of the cell phones for onward transmission to the Republic of South Africa. Then this very same question still exists, my lord. Then what prejudice are they going to suffer? Because now they've abandoned the application and the cell phones are currently in their possession, my lord, through the provisional order, my lord.
kude kukhinyabetheka labantu abanako-ke umshushisi nangabe ke lesicelo lesi singasele ukuqhubeka lesi lebe sikaze inkantolo isikhiphile evikini eliphelile ngokuthi lesekugcina singede sakhishwa lamuhla ngoba kude lapho batawukhinyabetheka khona ngoba phela nakho umshushisi ube sesuyaveda ukuthi sebayasixoxisa-ke lesi sicelo sokuthi-ke batabe sebayahamba nama-cellphone sebayawanika-ke lamaphoyisa ase-South Africa. Loko solokumile-ke lokuthi-ke yini-ke lokutabe sekusikhinyabedonyana nangabe ndikubuke ukuthi-ke digcinwe-ke sikhashana-ke emaphoyiseni inkantolo ikukhiphile kude lapho bona batawukhinyabedeka khona.
Yes. Yes, my Lord, it is our humble submission and or prayer, my Lord, that the provisional detention be extended to the next date, or rather, my Lord, for the record, until receipt of the application for extradition to allow us to take full and further instructions, inclusive of whether or not we will change our stance in terms of the detention application, my Lord, because we need to take full instructions, my Lord. That is what the order alteram principle dictates, my Lord. I cannot take it any further, my Lord, except that we are highly opposed to the application and that provisional detention may it be humbly extended, my Lord, as there will be no prejudice to be suffered by the applicants.
Kuzokwenza sicelo-ke sekuthi-ke le order-ke yesikhashana lebeyikhishwe-ke inkantolo kayigcutshekisele yona phambili nengokuthi-ke vele bayaphikisana ngokuthi-ke lesicelo lesi sale sikhishwa-ke le order yokugcina nekokuthi-ke futhi-ke bona bacela ukuthi-ke kubuye kutokhulunywa ngayo nase seyitholakele-ke lamaphepha lakabuya-ke e-South Africa ukuze ukuthi nabo batokhona ukuthi bathole isithuba sekuthi bakhulume-ke nabo umsolwa betenkani.
Yes, now no. Like I said, you can see that it takes away right. Yeah, it is good. What is it that will take away? What you intend to say what to hear.
Well, my Lord,
there is nothing, there is no received. They are always the facilitator. Our detention is not permanent. At some point in time, the fair machines and
as the court pleases, my Lord, I appreciate his lordship's question, my Lord. My Lord, this is the risk that we need to run away from. We do not know the contents of the actual application for extradition. That's the starting point, my Lord. Secondly, my Lord, whatever contents are contained therein, we do not know what bearing they have in the information contained or rather obtained from these cell phones, my Lord. Now, that is an issue, a key issue that requires us to take full instruction to be able to deal with. By way of analogy, my Lord, just by way of analogy, not to say I'm placing it on record per se. What if my clients are keen, or rather, what if procedure dictates that we be furnished with what is contained in the cell phones and what really they were seeking to achieve with the cell phones? Just to make an example, Your Worship, by way of analogy. So, but then the long and short of it, my Lord, is may we please be allowed this extension so that we take full instructions and the manner in which they were detained. It will all go down into the next phase or hearing for arguments on this particular issue, my lord, because now we would have had full instructions from our client. Because as a state, my lord, we do not have comprehensive instructions, mainly because we don't have the comprehensive application, my lord. Now, the gist, rather, my lord, what I'd love the court to appreciate is the issue of prejudice, either on the side of the applicants or on the side of the respondents, my lord, has been remedied by the court issuing a provisional, which we are all saying, may it kindly be extended, my lord, because the status quo will be maintained at the end of the day. Yes, my lord. That is the key application. You can have the provisional detention extended. We've got no objection to that, except the final and definitive order.
Hence, the gist of the matter is that there is still no formal application from the state for the case to be heard.
So manje ke usethe iphepha yaqhamuka kule live licela ukuthi limikiswe kilo lata ucela ukuthi ke limikiswe.
So it has been agreed between both sides that the matter returns on the pending seat.
Uvunyelwe nje ukuthi ke lizawupresent kuye ngaphambi kwenkanto ngomhla ka-20 kuMarch noma nasekutholakele ke lawo mahlelo.
Now there's also this
matter regarding detention or
Indlela yokubelana indaba le ukuthi lama-cellphone akatholakala sinike ukuthi agcinele ngalokusemthethweni.
when the matter was last before court, this court made a provisional detention of the said officer.
Nayivela ke le ndzaba ke le inkantolo ke yakhipha ke i-order ke yesikhashana.
Now, today, applicant's representative has applied that order be made by
Namuhla ke nasekuvelwa ke umshushisi ke wende isicelo sokuthi leyo order leyo sele iprivelela ukuthi sengiyonina.
Now, your attorney has objected or opposed that request by the prosecution.
Ummeli wenu ke usiphikisile ke leso sicelo kule senziwa ngumshushisi.
Now, he is not in a position to substantiate much on the objection.
Kuhle ke lokunganani lakavetile ke ngale kuphikisa kwakhe.
What the court accepts is that he still has to look at the papers, that is the main application to be brought by the requesting state, before he can take instruction of you.
Ke la kawo ngoba ukuthi ke usafuna ke abone ke lamaphepha latawuhamba kuleli vele tocela nini ukuthi nimikiso kilo bese ke soyakhona ukukhulumisana nani bese ke soyakhona ukuya tophendula phambi kwenkantolo.
Now, that has been countered by Mr. Noma, who said that the main application have no bearing on the detention application, because after all, these cell phones will not be used as in the extradition application.
Kuvetile ke nemshushisi ke lokuthi ke lama-cellphone ke ngeke abe khona ke kule ndzaba yalo noma kule sicelo ke saloko ukuthi ke nimikiswe kuleli vele abomakhelwane.
Our necessary implication is saying he has other sufficient evidence for purposes of this application besides the cell phones.
Sho ukuthi ke banabo lokunye ke bufakazi ke banabo ke ngaphandle kwalokhu kodwa mhlawumbe bangakuthola ke kulama-cellphone.
Now, the court has taken into account that there's not much to be suffered by both sides.
Ke inkantolo ke ibukile
The cell phones to be detained.
bonile ukuthi kude lokungakanani nokungaphinde beteka kubo tonke inhlangothi nangabe inkingo engakwazi igcineke.
But the court has taken into account as well that as much as the cell phones will not be used in this extradition application, the cell phones are interlinked to the extradition case, directly or indirectly.
Ke noma ke kude lokungakanani ke lokusetshenziswa ngala ma-cellphone kulesicelo sokuthi ke nihambe nibuyele ke ezweni kepha ke futhi ke lama-cellphone wona ayangena phela into angena ngandlela thina.
Now, this is because the extradition application is linked itself to the intended criminal trial in the requesting state.
Futhi ke kuyinto futhi ke lama-cellphone ke nawo ayaxhumana ke noma kuyahlangana nale kuqala lokukhona ke njengoba